Welcome in to a special edition of Coinage, a first ever debate addressing the best path forward to protect crypto customers on the space today. A very important topic, especially given the backdrop that we are now facing as Celsius founder Alex Mashinsky is arrested on fraud charges, and the company's now in a settlement, or at least accepting a settlement with the FTC for $4.7 billion. But what does it mean for crypto customers? Today, we're hoping to arrive at an answer to best protect crypto customers once and for all to help move the industry forward. I'm the host of Coinage, Zach Guzman, and I'm excited to have along with me today two titans of the industry, Custodia Bank founder Caitlin Long and BitGo CEO Mike Belshe. If you follow either Mike or Caitlin, you already know how we got here, a back and forth between them on the latest domino to fall, crypto custodian Prime Trust, now facing a more than $80 million shortfall, and customers once again facing the prospect of holding the bag. In this debate, Mike and Caitlin are taking two different views on answering the question today of how to best protect customer funds. Mike will be taking the side of a state-chartered trust company, and Caitlin will be defending the side that a Wyoming Special Purpose Depository Institution, or Speedy Bank, of which Custodia is one, is the better solution. And if you have no idea what that means, fret not, because we're going to dig into all of that in this debate. And guys, let me just say, I have no dog in this fight. I respect you both, and I was honored you both agreed to come on Coinage, a community-owned platform chasing truth in crypto. And Mike, you were the first to mention coming on Coinage, so I say hi to you first today. Thank you very much for coming on.
Thank you, Zach. Good to be here.
And Caitlin, as we highlighted in our trailer for this debate, you are fearless and one of the most respected people in the space, smartest people I know, I think, is you and Mike. So I thank you for coming on here as well today.
Thanks. It's an honor to be on. Happy Warrior.
Yes. And of course, we decided who would be going first in all the format for this debate ahead of time. And of course, you know, there was a back and forth in how we arrived here. If you don't follow Caitlin or Mike, just a brief recounting, because that is the debate topic today, is what exactly is the best path forward. And there will be differences, and we're going to hash that out in the format here. A brief recounting of how we got here, of course, was a question around Prime Trust and what exactly is the best path forward. Mike threw down the gauntlet, of course, calling out what basically Caitlin's going to be defending here as she goes first, the idea that Wyoming speedy banks are the better path forward to protect customers. Mike called that a, quote, myth, and the idea of this stuff being the better path. I believe the term was bullshit. So things are spicy today to get into all of this. And Caitlin, as we go back and forth on this, you'll have the opening statement. Mike will have a chance to open as well. 6 minutes each, 4 minutes for rebuttals, and then closing statements and questions as they come up. But Caitlin, you're the one starting us off to answer the question of the better path to protect customers. You go first in this debate.
All right. Hey, folks, if your digital asset custodian fails, which type of custodian provides you, the customer, better protection? A state-chartered trust company or a Wyoming Speedy Bank? Nearly all U.S. digital asset custodians today operate as state-chartered trust companies, and we just saw one of those fail, Prime Trust, a Nevada-chartered trust companies. Now, none of this is legal advice or advice of any kind. Consult your own attorneys and advisors. Diving in, Mike maintains that they're equal. They're not equal, and it's really simple. There's far more legal certainty in the event your digital asset custodian fails if it's a bank instead of a state-chartered trust company. It's not even a close call. A state-chartered trust company can offer digital asset custody customers protection by contract. A Wyoming Speedy Bank can also offer protection by contract. Plus, that's reinforced by state law and further reinforced by federal law. So let's start with the federal law point. A failed state-chartered trust company can be dragged into federal bankruptcy court involuntarily, but a bank cannot be. What's the difference? Uncertainty. Federal bankruptcy court subjects you to the risk of delays, preferences, and being strong-armed into taking haircuts, even if the bankruptcy court does find that the custody assets belong to you. That just happened in the Celsius bankruptcy, where the bankruptcy judge ruled custody assets were indeed customers' property. That's what Mike asserts in Prime Trust too. But nonetheless, they got strong-armed into a big haircut due to the potential for preference and clawback claims that against them that would have dragged on and on and on in litigation. To get rid of that uncertainty, they agreed to settle for a 27.5% haircut. But here it comes. Banks as legal entities are different. Failed banks cannot be dragged into federal bankruptcy court. Booyah. Failed banks have a special receivership process in which the receiver must consider the bank's customers. That's not true in federal bankruptcy court, where the goal is to recover assets into the bankrupt company's estate. So all else equal, were I a customer of a failed digital asset custodian, I'd rather face a legal process that pays attention to my interests instead of one that focuses on the bankrupt custodian's interests. This distinction is a key reason why asset managers in the securities industry almost always use banks as custodians. So, knowledge check. Number one, banks can't be dragged into federal bankruptcy court, but state chartered trust companies can. Number two, the federal bankruptcy process puts the estate's interests above customers' interests. And number three, you have more uncertainty and more risk of loss if your failed digital asset custodian is a state chartered trust company. Now let's turn to the second point, state law clarity in Wyoming. Three features of Wyoming law work together symbiotically to improve customer protection for digital asset custody customers of Wyoming Speedy Banks. A, using a bank as a legal entity. B, clear legal title in your name to your digital assets held in custody. And C, a bailment plus commercial law defined in statute. Bailment is the same law that covers valet parking and coat checks. When you give your car keys to the parking garage, you keep title to your car. It puts a twist on the meme, not your keys, not your coins, though. If you elect a bailment with a Wyoming Speedy Bank, your coins are still yours legally, even though you gave your keys to the Wyoming Speedy Bank for safekeeping. You keep clear legal title to your digital assets, reinforced by codification of that in statute and further reinforced federally by using a bank as a custodian. But wait, there's more. Wyoming Speedy Banks are audited and file quarterly financial statements publicly, while state chartered trust companies file nothing publicly. Speedy banks have far higher capital requirements, roughly 20 times higher than trust companies. Regulators examine banks far more frequently and in depth than regulators examine trust companies. Speedy banks have living wills, literally instructions for the receiver to, quote, break glass and do this if the bank fails. And Speedy banks can't even start offering custody services until the regulator and consultants have examined them and given them the green light. Again, it's no accident that fiduciaries in the securities industry prefer banks as custodians. I'll close with a point about Prime Trust. In Mike's tweet that ignited this debate, Mike asserted Prime Trust custodial assets are, quote unquote, the client's money. But Prime Trust's custody agreement is murky. For example, the agreement allows Prime Trust to use its customers' fiat assets under custody for Prime Trust's own trading, with Prime Trust taking, quote unquote, all attendant rights of ownership to customers' fiat assets under custody, where it can rehypothecate and keep all the profits. And for digital assets, it reads, quote, Prime Trust may, for convenience, take and hold title to custodial property in its own name. So Prime Trust, for its convenience, uses contractual terms that create uncertainty for its customers. And this is in addition to the fact, as you just learned, it can be dragged into federal bankruptcy court involuntarily because it's a state chartered trust company. So no, Mike, unfortunately, the facts don't support your conclusion that it's the client's money. No one knows how Prime Trust will ultimately turn out. I don't know why Mike started this debate, but I do know this. 2 Wyoming Speedy Banks are on the verge of launching digital asset custody services. And when they do, they bring to the US market the most customer-centric legal protections for digital asset custody. Let's hope that makes this entire industry up its game. Thanks.
Very well said, and under 6 minutes on the dot. Well done, Caitlin Long, in the opening statement. Normally, there is an advantage, I think, to going second in these things, Mike Belshe, but that was well said, Caitlin. So now we turn it over to you, sir, the CEO of BitGo, Mike Belshe, for your opening statement there.
All right. Well, by the way, thanks, Caitlin, for all of that. Let me just start with some facts, right? So Franklin Templeton has a custodial subsidiary called Fiduciary Trust Company. It's a 92-year-old financial institution. It's got $12 billion in assets under management. It happens to be a New York State chartered trust company. You might have heard of the Depository Trust Company, also known as the DTC, 50-year-old institution. Pretty much every equity in the United States is there, $90 trillion U.S. securities. It's a New York State chartered trust company. Brown Brothers Harriman, institutional trust company. Also, surprise, New York State chartered trust company. You can probably see where I'm going here. New York Life Trust Company, Bank of New York Mellon, Mizuho Bank USA, subsidiary of Mizuho Financial Group, 1.8 trillion in assets, also New York State Chartered Trust Company. BitGo Trust Company, New York State Chartered Trust Company. So look, to be honest, I'm not even sure why we're here or how this got turned into a game of a debate. Let's keep it the topic with what was on Twitter. There's a lot of things that Caitlin shared there about Celsius, but they weren't a custodian. Like, they should have been using a custodian. There's no debate there. What's going to happen in their bankruptcy has nothing to do with custodians or banks. They were just a fintech company. Also, the other things about SPDIs not related to bankruptcy is not where this contention started. We're specifically talking about, do these bankruptcy laws help at all? And SPDI bankruptcy law doesn't solve a real problem. I know you've got a claim that, allegedly it's got some sort of superior bankruptcy code, and you're talking about it and banks and how they get pulled into receivership, et cetera. Look, all that exists for state chartered trusts. It's well documented. We can get into the details if you really want to. But look, when I first heard you make this claim about statutory bailment, I was intrigued. It's like, wow, that sounds interesting. I did a bunch of research. I verified our own opinion letters. I went and hired a bunch of lawyers. And in the several years since that happened, I have yet to find one single attorney anywhere that's going to write an opinion letter that says that any of these New York State Chartered Trust Companies don't provide bankruptcy protection to their clients. Let's be realistic. If trust companies don't provide bankruptcy protection to their clients, I'm not even sure why we would have them. It's probably the single most important thing that they do. But it's not just me. Don't take my word for it. How about the attorneys from Franklin Templeton, Brown Brothers, DTC, all of their clients and all of their attorneys? This is just not an issue. So yet here you are, somehow stating that the Wyoming statutory bailment is fixing a problem. I don't know what problem is fixing. So we've never had a single ambiguity in court about the safety of client assets, and clarifying something that's already clear isn't actually solving an issue. All right, let's go and switch gears to case law. And one of the things I've challenged you on, Caitlin, is like, okay, show me the example in bankruptcy court where client assets were reallocated by some judge to pay the creditors of a trust company. Somehow they skipped the line and got higher priority. There's none. Now, in the Twitter thread, you cited independent trust. But independent trust had a different issue. They lost the client assets. And Wyoming is not going to replace the client assets when they're lost. No other state's going to do it. You either got to have your own insurance, you got to have FDIC that would cover it. There's nothing about SPDIs that requires FDIC insurance, as you know. Or you'd have to have civic insurance. Anyway, something. So my point is that whether you have statutory bailment or not, it's immaterial. This was never an unclear point. So look, the good news is we have a whole bunch of great options for digital asset custody today. And this just wasn't possible even a few years ago. I love Wyoming SPDIs. I think it's great that Wyoming has been explicit about crypto in its legislation and regulation. I love that South Dakota has been all over digital asset custody for the better part of a decade. I love that New York has now got 8 digital asset trust companies that are chartered. But we need to focus on real custodial issues. We need to focus on the issues that would have prevented the prime trust, not talking about how you chop up an already partially eaten pie, which is what's going on at Prime Trust. So what got me worked up on Twitter is that you claimed that Wyoming law somehow would have helped the folks at Prime Trust. And it's just not true. These were not bankruptcy issues. This is an insolvency issue that happened before bankruptcy. There's no state, Wyoming would not help these clients. You're creating a false hope for the poor clients that were stuck there that might lose money. And you're also creating confusion that Franklin Templeton is not doing something right, Brown Brothers is not doing something right, all of these other traditional financial companies are doing something wrong. So at some level, I think, you don't have very good counsel. I mean, it's an interesting concept that you've presented, but there's no evidence that there was ever any ambiguity about it. And it kind of just looks silly to be calling out all of these traditional firms that certainly could be banks if they wanted to, when they're perfectly safe in what they do today. This is what trust custodians do. A big part of it is bankruptcy protection. All right, that's all I got.
All right, you guys pretty much matched each other there in the opening statements, coming in at about 5 minutes each, so thank you for sticking to the guidelines. This is the point, Caitlin, when we'll turn it over to you for rebuttals, but before we do, I just want to let everyone know on the space, if you are listening along, to tap in and hit the button on the right to, throw us your replies, your questions, which we'll pose to them in the next round here as we continue moving forward in this debate, as well as retweeting the space, gets more people in. Obviously, I don't think there's a lot of spaces digging into real issues like this one with people as, shall we say, I guess, respected as Mike Belshe and Caitlin Long are. So please do throw us your questions and retweet the space. There were a couple things that you brought up there, Mike, that I just want to comment on before we turn the rebuttal over to Caitlin Long, because I think the news of Celsius and what's being brought against Alex Mashinsky is interesting in hindsight, looking back to interviews that I even had with him in 2021, and kind of the irony of the fact that Prime Trust was actually the custodian that backed out from working with Celsius back then, and first, I think, called some of those red flags in what Celsius was doing, saying that they were endlessly rehypothecating assets, and that kind of sparked a lot of, I think, people in the industry were starting to look at what exactly are these terms and conditions for all of these different companies promising, and what happens when shit hits the fan, for lack of a better term there. And I think, it's interesting to look back at that interview in context now. But Caitlin, I'm sure you have a lot of things to mention in rebuttal to what Mike just said. So 4 minutes each are what we have for these rebuttals, and we'll get into Q&A after. But Caitlin, 4 minutes to you.
All right, thank you. Yes, I'll summarize Mike's points, basically 4 points, and cover them directly. First of all, he talks about a lot of New York trust companies, brand name financial institutions have trust companies. Absolutely, that's true. That's better than money transmitters, for sure. No question about that. But here's the issue. They're state-chartered trust companies. If they ever went bust, they go to federal bankruptcy court. What happens is that they can be involuntarily dragged there, and that could happen in the Prime Trust situation as well. The only entities that cannot be involuntarily dragged there are banks and insurance companies, and there are a couple of other things in 11 U.S.C. 109. But in the financial industry, it's only banks and insurance companies that cannot be dragged into federal bankruptcy court where you have all of that uncertainty. That is a fact, and Mike did not refute that because he can't. There is a fundamental difference in the bankruptcy court treatment. Banks can't be there, state charter trust companies can. He then says there's never been an unclear issue. Oh boy, Mike, I think you better dig up the case law. I read 8 cases last night, including cases involving state chartered trust companies that tried to fight being dragged into federal bankruptcy court and lost. They were deemed non-banks, therefore could be involuntarily dragged into federal bankruptcy court. And by the way, when you're dragged into federal bankruptcy court, your clients are taking losses. Now I'll talk about his point about Celsius in a moment, but the interesting point is that this was a failed state chartered trust company in Oklahoma that challenged because it said it tried to be a bank. And the state said, no, you're not authorized to take deposits under state law. New York trust companies like yours are not authorized to take deposits under state law either. And so you cannot guarantee that your clients aren't going to face federal bankruptcy court if a New York limited trust company goes bust. It is therefore, to his third point, where he says the banks have the same level of treatment as trust companies, it's just prima facie not true, because banks can't be dragged into federal bankruptcy court. And let me come back to the ownership clarity. Here's what's interesting in the Celsius case. It didn't matter in the end that they didn't have a trust company or a bank charter because the judge said those custody assets belonged to the clients. The judge created what is effectively a constructive bailment. Okay, so the judge said those custody assets actually were owned by the clients, but he didn't let them take their assets. And here's why. Because there was a credible threat of clawbacks and preferences against those customers. And so what ended up happening is that the custody customers as a group got together and had settlement talks with the bankruptcy lawyers and agreed, because of that uncertainty, to take a 27.5% haircut. Any company that's dragged into federal bankruptcy can be what's called strong-armed. Even if they have perfect property rights, they can be strong-armed. I would underscore again, were I a customer of a defunct digital asset custodian oh boy, would I rather be in a receivership regime that is required to take customers' interests into account rather than a federal bankruptcy court, which is aimed at something different, which is maximizing the assets of the estate. That's not going to take the customer's interests into account. And situations like the Celsius custody outcome could end up happening.
Yeah, Mike, I think I might just reiterate, and I assume where you're going to go with your rebuttal here in it, but I'll just repeat the claim there in terms of banks can't be dragged into federal bankruptcy court, and the idea of trusts can be. It seems to be one of the sticking points in this back and forth, just flagging that one again. But you too, sir, have 4 minutes to rebut.
So, look, I mean, Caitlin, you're conflating two very fundamental and basic concepts. One, whether an entity is subject to bankruptcy code. Number two, whether the assets held by that entity are bankruptcy remote. It's not the same thing. And you're here telling us that just because it's hauled into bankruptcy court, that somehow a judge is going to decide to take client-owned assets, segregated from each other, segregated from the trust company, and decide to use that to pay bills of the custodian or pay back its creditors. When you get into the bankruptcy code, you will see there is clear priorities of what gets paid first, and the clients are right up there at top. So, I don't know, you keep kind of saying this is an issue. And if it is an issue, then why don't we have examples? Now, you said you found 8 of them. The one you put on Twitter was completely not an example. That was an example that was independent trust. That was where they actually just lost the money, and there's nobody that would have paid back that money. So in the case of Prime Trust, and I'm just going off of what the Nevada regulator said here. Unfortunately, assets were lost. A wallet, private keys were gone. And once it goes into bankruptcy court, that money's already gone. Wyoming doesn't replace it. Nobody replaces it. So the debate here, Caitlin, is not about the nuances and the fundamentals of like how bankruptcy works. It's a silly thing. And heck, if you want to go have that, just go again, talk to Franklin Templeton, talk to Brown Brothers, talk to all of these guys. If it's so great to be a bank instead of a trust company, why didn't they do that years ago? They certainly could have. This is just not a real example. You keep saying bankruptcy court is a lack of clarity and there's some problem, but you cited 0 actual examples of it. And it's never happened where that is an issue for crypto regulated companies. Now you can talk about Celsius, but again, remember, they are not a custodian. They're not a bank. They're none of these. So it's, again, just irrelevant stuff. All right. Let's see. Let's do one more thing. Let's take one more.
You still have more time. You got 2 minutes working here, Mike.
So what would help? Let's talk about like things that actually can matter. And I think that we in the industry can help the regulators here. So state chartered trust companies, banks, SPDIs, yes, we all do annual audits. Why didn't the audit flag this? Why didn't the regulator know that the wallet keys have been lost? Because according to the Nevada statement, it seems like it happened like a year and a half ago. Well, an audit happened for sure. The regulator saw that audit, but somehow the audit didn't catch it. So the audit must not have actually checked that Prime Trust could move those funds, because if they had, it would have been flagged a year and a half ago. That's an example of things that we can help regulators with today that would actually start to catch cases like Prime Trust before they get big. And I think that's where we need to be focusing our efforts. Talking about bankruptcy code, I'm sorry. Again, Franklin Templeton, Brown Brothers, the DTC. This is not an issue in bankruptcy court. There's no judge that's going to have any uncertainty about, gee, should I steal from clients in order to pay for the creditors to this trust company? Just fake news.
I will say, so far, everyone has been very respectful of the format, and I appreciate that. We've made it through basically halfway of this debate of going back and forth, and this is kind of the format of now as we approach Q&As. I'm going to trust that we can all operate here fine to basically throw some questions out to you individually. And Caitlin, in the ping pong format, I suppose we'll come back to you first on this one because it does sound like Mike is really hammering here and on the point that examples are sparse in this being a bit of an issue. And I think, for everyone watching this, right, in the framing of how do we help customers, myself included, who have basically lost money on BlockFi going down and now waiting to see what the hell happens and how much we all get back. The question there being, I guess, is there a better way to protect against this idea of just money being lost, or what, again, allegedly happened at Prime Trust, the idea of keys being lost and not being able to access that money, to Mike's point, eventually being left with people trying to divvy up half of a pizza pie, and someone's going to lose in that scenario. So, I mean, what is the real issue that is so important here in looking at it through the lens you are?
I got a big smile on my face when Mike was talking about that, because it just proves that he hasn't read the Wyoming rules. Because guess what? Since 2019, it has been in the Wyoming rules that Wyoming speedy banks have to do proof of reserves, not only prove that the reserves are there, but sign a message to prove that they control the private keys. This is addressed by Wyoming and no other state in the United States. But Zach, I grant the point that this debate is a debate about something we all hope is a rare occurrence, which is the failure of a digital asset custodian. And the wonderful thing about what Wyoming did was step up, working with several of the industry CTOs, and define what is it going to take in order for you to become a chartered speedy bank that can provide digital asset custody services in the first place. Remember, before a Wyoming Speedy Bank can even launch digital asset custody services, it has to go through several audits. And of course, we just talked about the proof of reserves, where it's not just proof that they're there, but proof that the custodian controls them. Mike, thanks for answering my question and making it clear why Wyoming law is so awesome.
Mike, I don't know if you want to respond to that directly, but I mean, the question here of where we go, what's happened to a lot of these places when you are divvying up the pie, you can look at, I guess, the banking industry and the idea of what happened at Silicon Valley Bank and how the Fed stepped in, how FDIC was applied, and, the depository fund there that banks do pay into, right? And you think about why the government was so protective of saying taxpayer dollars are not being used to fill this hole, what the better solution might be as an industry when we look at this to say, how should crypto regulate itself? If you don't want the government stepping in and saying, look, we need to protect customers against this, what's the better path forward, if there is one, to maybe copy from the old traditional banking system of addressing some of these issues?
Well, there's a lot in there. Let's see. First off, on SPDIs, look, I said it already. I love SPDIs. I don't have any problem with them. I think they're great. So this never was a debate about that. The debate was about whether the bankruptcy code would have been some sort of a win, and it's not. What we do need, however, is awareness of what types of things do work. And so some of the safety and soundness controls from traditional banking, sure, absolutely, they apply. I don't think there was any rehypothecation going on at Prime Trust. We don't know. The Nevada report didn't say anything about it. It said that they lost the asset. But when you start getting into
we should note, by the way, that BitGo, was looking at a deal to acquire Prime Trust and backed out of that once, all of this came to light. I assume, that there was something gleaned or that something happened there in terms of what the decision was before and then after all this came out.
Yeah, but look, the way you secure assets is you eliminate single points of failure. And this is not unique to crypto. This is the way you would do it in any asset class. It turns out to be more important in crypto because these are bearer instruments and they're globally usable everywhere. So, what do you expect from your trust company, your bank? You expect financial controls, you expect operational controls, you expect technology and security controls. And the deeper that we can go in terms of making sure that those that are taking custody on behalf of others, taking a fiduciary responsibility, which is what, of course, all the state chartered trust companies do, those we should be fortifying. So this comes into SOC audits and what should be in that SOC audit, and how are the backup keys held? There's been cases where not here, but non-custodian folks have lost backup keys. There was a lawsuit with Stakehound, about that. This is hard stuff. It's relatively boring. But if we focus on basically all of the past failures in crypto, like what happened at Mt. Gox, what happened at Quadriga CX, what happened at FTX, and how do we prevent those things? That's what we need to be focusing on. And it's simply not true. I'm not trying to diss SPDIs for being, they're moving things forward in the right direction. It's the bankruptcy one that's particularly problematic. It just doesn't make any difference. It's solving a non-problem, as evidenced by the fact that A, everybody's been using this for years and it's never happened. And B, there's literally zero case law where it's ever been a thing. So anyway, those types of controls, eliminating single points of failure, making sure you own your own technology enough that you can actually operate it effectively appears to be a problem with Prime Trust. So we
Well,
should
I
be
think
focusing
that's
on?
yeah, I feel like that's kind of one of the things too. Again, ironically, in a space that is supposed to be trustless, there is still a lot of trust put into custodians to again manage their jobs, to do their jobs effectively, I suppose. And Caitlin, I guess if I can turn back one question to you, and a reminder for anybody listening on the space right now or watching, the way to vote for a winner, that is essentially what we as Coinage as a community-owned show enable, is the idea for people to vote in. You can go to coinage.media/vote to start voting, and this will stay open through the weekend. But Caitlin, when we look at, I guess, what Mike's saying there is clearly there are laws in place, I think, for people to be good actors, and laws and drawing the line for what happens when they are not good actors. Of course, the Wyoming law puts in place certain rules and restrictions for how this should go. But in the event that it doesn't go the way it should, right, what kind of protections are there? Because what happened in a lot of other jurisdictions could happen to a Wyoming Speedy Bank, right? You're talking about audits,
Sure.
but things could happen. And you could be, to Mike's point, caught in the same position where you're dealing with, all right, what do we do now?
And this is where Mike just doesn't understand it. Just because he's asserting something doesn't make it true. Oh boy, Mike, you really should go back and ask your lawyers to pull all the cases of state chartered trust companies that were forced into federal bankruptcy court, and their custody customers took losses. It will happen. Here's the difference. I'm so glad you asked the question, Zach. With Wyoming, you have, again, the contractual rights reinforced by state law protections, reinforced by that federal law protection as well. So here's what's going to happen. Because the bailment is something into which not only you have to clearly define in the title in the contract, but the state law has the customer electing into it. You don't have a question. You don't have the uncertainty that, for example, happened in the other Chapter 11 cases over who really owned the assets. There, it is crystal clear who really owns the assets in a Wyoming Speedy Bank, and that is the customer. And because Wyoming Speedy Banks are prohibited from rehypothecation, Mike, the contract of Prime Trust itself makes it clear that they had legal ownership of the customer's custody assets. An IOU was created, a debtor-creditor relationship. It's going to be very difficult because of that for the custody customers of that fiat portion of the assets under custody to make the case to the receiver that those assets belong to them and not to the company. But here's the thing, Zach, what's going to happen is in the event of a Wyoming Speedy Bank, because it is so crystal clear and because you can't run to federal bankruptcy court where a bankruptcy judge can break the contract, if there is a Wyoming Speedy Bank, let's give the example that one root key was compromised, but the other root keys are safe. And the custody customers have their custody on the root keys that were not compromised. They would be able to withdraw their assets immediately. In the other Chapter 11 bankruptcies, they had to go through the bankruptcy process where they got strong-armed into taking discounts in order to get their assets 11 months later. The Wyoming process is absolutely aimed at improving the clarity, reducing the uncertainty. And let me close by saying, Mike keeps throwing the names of these big financial institutions that have trust companies. How come none of them are custodians for 40 Act mutual funds and registered investment advisors? There's a reason why the fiduciary asset managers almost always use banks as custodians, not trust companies. Those trust companies are not there to do the ERISA and 40 Act mutual fund type custody. Go look at who is the custodian of most of the big funds. The vast majority use banks. There's a reason for it, Mike. And just because you assert that something is true doesn't mean it is.
Mike, your response?
Well, look, I mean, she's made a lot of assertions there. Franklin Templeton, pretty sure they're a fiduciary. But if you don't want to believe me, okay. On the Wyoming process about if you lose one root key and not the other, that might sound better. But let's say you had, $100 million worth of Bitcoin and you lost half. That process that was just, and let's say it was evenly distributed across those two root keys, then you lost half of it, not the other half. Well, if you happen to be the client that was on the one that got lost, you get zero, I guess. And if you happen to be a client in the other pool, you get all of yours. So I know Caitlin wants to say that that's more consistent or more fair, or it's bailment or whatever. But I mean, at the end of the day, there's just no good way to split $50 million across people that have in aggregate $100 million. And, I guarantee you that if it goes to Wyoming, the regulators going to have to figure out how not to play favorites. They won't be able to give it to one guy and not the other guy. But all right. Anyway, this is kind of the boring stuff that really doesn't matter. Let's get back to the stuff that really does matter. And we should look at each of the failures that have happened. FTX, I think, is a great example. FTX wasn't even using a custodian. That's problem number one. So they were able to perpetrate massive fraud, right? So how do we help here? I think Caitlin and I would probably agree. I'll assert that we'll agree that if they had used a custodian, we might have been able to catch the fraud. But then how do you want them to use the custodian? This is another angle that we don't talk a lot about in our industry. And in fact, I feel like I wish I had pushed on this harder. A lot of exchanges, other financial institutions want to use external custody in an omnibus pool. And that's okay. That's certainly better than not having separated it, because now you got some checks and balances. But when assets are put into an omnibus pool, it's very difficult for the custodian to really know kind of what's going on. All they do is they see somebody instructing to move. So for instance, BitGo actually runs 4 trust companies. We run 2 here in the United States, we run 2 in Europe. Our German entity does things a little bit differently. And this is because the German regulator requires it, where we actually have to know each client all the way down to the client's client. So we can still hold them, store them in an omnibus pool fashion, but we have to know what's allocated to each of the individual clients. And this is what FTX clients actually wanted. With an omnibus model, you might have been able to catch the fraud early. You certainly would have protected FTX from like a BitGo type of failure. Mm-hmm. But the clients wanted to be protected from both a BitGo failure and also a FTX type of failure. And that could only be done if you're constructing the custody such that you can see all the way down to the end client in two different parties. So look, that's an example of things I think we could add to market structure that would really help real world cases, as opposed to, frankly, this academic argument about how to split up a half-eaten pie.
Yeah, we've hit pretty much, I think, the time that we allotted for Q&As. Before we get to closing arguments, I again want to remind everybody on the space that they can help us choose, again, as a community-owned show. It's not me calling balls and strikes. I was here with the stopwatch, and thank you to Mike and Caitlin for following the rules that we agreed to in this debate. If you enjoyed this, please throw a like to it, follow Coinage, and we might be able to host a little bit more of these debates to move the space forward. And again, I have so much respect for you both. I just want to say that. And you guys both coming on here to have this discussion, I think helps a lot of people and, again, moves it forward, because I'm pretty sure I speak for everyone in crypto that we're goddamn tired of seeing a bunch of these companies continue to take people's money and have to deal with these bankruptcies. And again, myself included, if I lose any more goddamn money, I'm going to be real broke. So this is an important topic for us all to be talking about. Before we get into closing arguments, again, follow Coinage and coinage.media/vote to help us choose a winner. Caitlin, we have 4 minutes for closing arguments is what we have slotted. We've gone back and forth on a few different issues. Again, I think in the spirit of kind of moving the space forward, what exactly are the strongest arguments, again, to have you be the winner, to put Wyoming Speedy Banks more on the map than they already are? 4 minutes to do closing arguments here.
All right, thank you. The bottom line, folks, is the Wyoming Speedy Bank structure offers certainty in an uncertain time. Mike keeps trying to change this debate to, well, let's talk about before the failure, but that wasn't the topic of the debate. We all agree. And in fact, I love what he's talking about segregation of wallets and ensuring that you're not using omnibus account structures unless the customer expressly requests that. Custodia doesn't even plan to offer that, not for a long time. Everything is segregated. Everything's in the customer's name, and the title to the assets is legally clear. But Mike keeps getting mixed up. He keeps saying that banks and trust companies are the same. Mike, they are not. And the trust companies can be dragged into federal bankruptcy court, where almost certainly even a custody customer is going to be taking a haircut. I fear that that's going to happen in prime trust as well, because again, they're a state charter trust company that can't keep themselves out if somebody tries to involuntarily remove this from Nevada's hands and put this into federal court. And you have not refuted that. That is the underlying difference between a Wyoming Speedy Bank and a state chartered trust company. the other piece of it is that the receiver's hands in Wyoming are tied by the Wyoming statute. Mike made the comment pshawing the Wyoming receivership structure and saying, well, they're going to want to play favorites. No, they're not. They can't, because the law says they can't. And if they do try to do something outside of the statute, then the custody customer, because you have clear property rights, can go and enforce those clear property rights against the receiver. You mentioned that there are losses, and one thing that you're glossing over in the example that you just laid out is that insurance plays a huge role in risk management in this industry. And when you see the Wyoming Speedy Banks launch, at least in one case, you're going to see, because we're looking at this as the customer's property, that we'll be arranging for the customer to buy up a lot more insurance if they want to. Just like when you park your car at a valet parking garage, and if it gets stolen, it's your insurance policy that pays, not the garage's insurance policy. The garage has some level of policy that will will provide coverage if there's negligence, but the property itself is covered by you because the title stays with you. And we will be arranging the ability for customers to buy more insurance if they want to. It is a different model. It is a clearer model. And at the end of the day, what is the biggest problem with a state charter trust company? Why is it that the big asset managers don't use trust companies as custodians for the big fiduciary asset management funds? The answer is uncertainty. They don't want to be dragged into federal bankruptcy court. They want the certainty of a bank's receivership regime and the certainty that the assets that they're managing for their customers are outside of the bankruptcy estate, and they can take them instead of having to wait through federal bankruptcy court. That's the fundamental difference. There is a difference. That was the topic of this debate. And Mike, I hope that you learned something from this and use this as an opportunity to go back, because I think everybody can learn once the Wyoming Speedies come into the market from the better customer protections. I would agree with you, Zack, as a closing statement. This industry has a terrible track record of service providers putting the company's interests before those of the customers. And the Wyoming Speedy Bank regime forces the companies to put the customer's interest first, and gives them the legal clarity to reinforce that in the event something goes wrong. That is meaningful. Thank you.
All right, Caitlin Long's closing statement there. I appreciate that. And Mike, we did go over 15 seconds, so I'm going to be honest here. I bent the rules there, and I will bend them for you equally if you want 4 minutes and 15 seconds to also go with your closing remarks, my friend.
Well, look, I mean, we can talk about certainties real quick. Caitlin asserts that there is uncertainty, and yet she can't provide a single opinion letter from a lawyer anywhere that says that state charter trusts don't provide bankruptcy erroneous. She also can't provide a single example of where this has happened. She said she knows of 8, but she didn't name them. The one she did name on Twitter is easily refuted as not being that case. So maybe, but I don't know, she didn't list it. Look, I think the basic thing is she's confusing entities that go into the bankruptcy process from assets that are bankruptcy remote. It's not the same thing, and it matters a lot. In terms of Wyoming, can they play favorites? Look, I mean, imagine half again, back to that example, imagine half of the clients at the Wyoming SPDI get their money and the other half don't. I think there's going to be some lawsuits about that. And I don't think it's just going to resolve where everybody's going to pull out their money and be happy and the others are going to be unhappy. It's just not going to work that way. On insurance, look, a lot of this argument is academic. If you've actually been operating a multi-billion-dollar custodian, which one of us has, then you know that there actually isn't insurance capacity to cover all digital assets. Global underwriting capacity for high-quality insurance of digital assets is probably in the $46 billion range, and that's shared across all of the different parties that are competing to get insurance for their assets. So, Wyoming might, actually, I don't know if it requires insurance or if it doesn't require insurance. I mean, Caitlin doesn't have FDIC insurance on the fiat side, on the digital asset side, I don't know why they would require it if they don't require it on the fiat side. But maybe, look, there's just not enough underwriting capacity, even if it was required to have it. So once you get into like the real practical points about insurance, you realize that kind of claim takes you so far. The next thing you have to have is the other additional advanced controls about how do you manage to secure assets when you've got limited insurance and yet a large pool of assets. There's ways you can do it. There's technological things you can do. There's auditing things you can do. That's what we do at BitGo. We've been doing it for a long time. So the one last thing I want to point out is like the SPDI does not prevent fraud. Okay, Mt. Gox was fraud. Quadriga CX was fraud. FTX was fraud. Prime Trust might turn out to have been fraud. And there's nothing from SPDI that's going to stop that. I think where the industry needs to really focus is on rules that will catch fraud earlier, make it harder to perpetrate, because, Zach, I'm empathetic to you and everybody else that's lost money. There's way too many people who lost money. It's that fraud component that we need to stop. Now, there's some good things in SPDIs that start to go towards that. Great. Other regulators are picking that stuff up too. But the bankruptcy piece of the SPDI is just frankly a non-problem. There's no uncertainty about it. There's no case examples of judges taking away assets from clients in order to give them to a trust company's creditors.
I think, having this debate has been super helpful for everybody. I think, obviously, again, when we line this up, this is a very technical discussion we're having. It's above, I think, a lot of people's technical and legal understandings as well, including myself in that. And it's been helpful to kind of hear your points back and forth. And I would remind everybody again, this is all on chain. The winner will be decided on chain by Coinage NFT votes. So coinage.media/vote, it's there. And right now it's 50-50 because voting has opened. But in the spirit, I suppose, since we've now closed arguments on which one of these sides will win, obviously there's been a lot of back and forth leading up to this. Mike, you've repeated the point that you're not necessarily a hater of Wyoming speedy banks, that you see a lot of good things that could come from them. I feel like, I feel caught in between this. I felt a little caught in between this as we put this together because, again, there are two sides here. You guys are obviously hotly debating against each other. But I want to kind of wrap this up in a way to at least, again, bring the space together and forward to maybe have each side here mention something, and it's not going to be mushy-gushy and saying anything good or bad, but the last chance to get anything out there on the record, since it's really hard to have these debates on Twitter. I feel like sometimes it becomes not what anybody wants, but I guess, Mike, I'll just ask you, after having this debate now that it's closed and we're not making the points anymore, if there is anything.
We're all on the same team. We actually see tremendous opportunity to de-risk and increase transparency of the financial system, and crypto companies to be fighting each other about like what's the right bankruptcy code is insane. Like, we should be talking about solutions and working together, and casting shade on a state chartered trust company that's absolutely doing it right, that's absolutely knocking down as best they can, any ability to defraud, makes no sense. Now, also casting shade on TradFi, and saying that Franklin's not a fiduciary or that these other things are insufficient is not going to get us very far. So I think the crypto industry, I guess I got a little bit belligerent there. I'll retract that last statement and try to be more loving. I also respect what Caitlin is doing. I respect what Wyoming is doing. I'm really glad for it, and I think it's a step. Everything's got trade-offs. Some good and some bad about it. There's a lot more important things than bankruptcy. I don't know if Caitlin would agree with that statement. When it comes to custody, there's way more to be done that would prevent the failure than worrying about what happens after it fails. And I think most customers, Zach, I'm suspecting you're in this case, you want a best outcome from bankruptcy, but what you really wanted was to never have been in bankruptcy. And I think we can do a lot more. And I think actually we are trying to do a lot more together.
Caitlin, I also would offer the same opportunity for you as well.
I find it hilarious that Mike's lecturing me about having this, because Mike started this whole thing by calling Wyoming law an expletive. Okay, Mike.
Yes,
So
I think the word was bullshit. Yeah.
there you go. Right. So, Mike, you started this, and it's just sweet that you're lecturing me on having this argument. Of course, I stood up and explained, and I really, truly do look at this as an opportunity to educate you and everybody else who's listening. Of course, you pay a lot of attention to what happens in those edge case scenarios. You're absolutely right. That is an edge case. We're hoping that no crypto entity ever fails ever again, and that the fraud is all weeded out. The great news is that there is something that is actually trying to weed out the fraud. It actually would have found, I think, the prime trust situation, because the regulators require not just an audit as to whether those reserves are there, but whether the custodian actually controls the keys. And prime trust, if what is alleged that they lost access to that wallet, they would have failed that test, and they wouldn't have been allowed to continue to operate for 2 years, allegedly, after they lost access to that wallet. Let me also close by saying the fact that prime trust took with the indicia of ownership of a certain percentage of their customers' assets is a huge problem. This is exactly the kind of behavior that I called out with FTX, that I called out with Celsius, the rehypothecation of customer assets. If you're doing anything like that, which most of the companies in this industry are doing in their earn platforms, and that company goes down, it's going to be very, 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 very difficult for the lawyers representing the customers to argue that those assets were the customer's assets. I'm sorry to say. And that's exactly why that the haircut was so big in the Celsius case. It really does matter for you to think about these edge cases. Fiduciaries especially have to think about the edge cases, especially ERISA fiduciaries who are personally liable if something goes wrong. Mm-hmm. And it does really matter which legal entity. Again, a bank as a legal entity gives you far more certainty than any other non-bank entity.
Well, I will end with this. I do, of course, out of anybody who's building in the space, a lot of this is open, a lot of this is unclear, and a lot of it comes down to doing the best with what you got when you're building these projects. Myself included, in building a community-owned show. You know, billionaires own the media. This is a decentralized project here at Coinage, and I appreciate everyone who has minted an NFT to co-own this with us. It's a new experiment. It's a new model, and I have respect to you both for trying to figure out the right way to do all of what you guys are doing in protecting customers, and two paths here again. A reminder for everybody who's listened, coinage.media/vote for us to find out who won this debate. But Caitlin Long, Mike Belshe, thank you both for coming on Coinage again to debate this one with us. And hopefully, maybe, who knows, maybe we'll have to reopen this conversation again down the line. But Caitlin and Mike, thanks again.
Thanks, Mike. Thanks, Zach.
Thank you. Bye-bye.